Welcome to our webinar titled Living with PNH, Workplace Rights and Responsibilities. Thank you for joining us. My name is Lee Clark, Director of Patient Services, and I'll be moderating the presentation today. I would like to recognize the generous support of Novartis for making the Living with PNH program possible. This series is designed to help inform PNH patients about their legal rights in the workplace under the American Disabilities Act and to help them navigate those difficult conversations with employers about their needs for accommodations. Before we get started, I'd like to bring your attention to a few upcoming educational programs and awareness events within the foundation. We've already started our 2023 Patient and Family Conference Series. Our next conference will be held in Salt Lake City, Utah on July the 15th, and registration is currently open. You can register directly on our website. Each month, we host virtual support groups. All of our support groups are held over Zoom, and you can either log in with your computer or call in to participate. Our support groups are all volunteer-led, either by patients or caregivers just like you. You can also register directly on our website. Once you register, you'll receive a confirmation email with the Zoom information for the meetings. Next, each month we host webinars. Our next upcoming webinar will be held on May the 15th. And this is a webinar where Dr. Emma Gork will be talking about the updates and what was presented at the American Society for Hematology meeting in December of 2022. She'll be specifically talking about the research updates for aplastic anemia and PNH. Every year we host March for Marrow walks, and these are awareness walks. Our next walk will be held in California, and it's actually going to be tomorrow. There is still an opportunity for you to register for the walk and participate. You can also participate virtually if you cannot attend in person. As we get started, I'd like to talk a little bit about if you lose your connection during the webinar, you can still participate by using the call-in number in your reminder email to be able to listen to the program. Good news is today's program will be archived to our website within 2 to 3 business days. You will be notified by email when it is live and ready for viewing on demand. Immediately following the presentation, there will be a question and answer session. Please feel free to submit your questions at any time during the presentation. To submit a question or comment, open the Q&A window in the lower part of your screen. Type your question in the small text box window. When you have finished typing, just hit enter. We'll do our best to get to everyone's questions today. We did have some participants who did send in questions in advance. We did forward those to Mr. Mills, so he will be incorporating the answers to those questions throughout the presentation. When asking your questions, to help me best manage all of the incoming questions, I asked you to help me out with 2 things. Submit your entire question all at the same time. Second, please do not share any private health information in your question. Our speaker will not be able to answer any specific questions related to healthcare. Our specialist today is Christopher Mills. Chris is an attorney with 25 years of legal experience. He has provided pro bono legal representation to AAMDSIF for over 10 years and has previously represented numerous individuals living with blood-related cancers and other chronic conditions with respect to workplace issues and disability claims. He is presently an associate general counsel at a government-sponsored entity. Prior to that, he was in private practice with a large Washington, D.C. based firm for 20 years. He is licensed in Virginia and Washington, D.C. Chris received his law degree from George Washington University Law School with honors. He also has undergraduate and graduate degrees in civil engineering and architecture from Catholic University of America and Johns Hopkins University. It is my extreme pleasure to welcome Chris. Thank you so much for joining us.
So thank you, Lay. I'm gonna just share my screen here. Hopefully everyone can see that.
Yes.
So again, thank you. It's a pleasure to be here and welcome to everyone. And we appreciate you taking the time to join us today for Living with PNH, Workplace Rights and Responsibilities. The goal today is to provide you with some information related to some of the laws that might be relevant to those with PNH that are working or perhaps no longer able to work. And while we've focused on PNH in this presentation, some of these same concepts I think would be relevant to others with other bone marrow failure diseases. I'm not going to say too much more for at least nice introduction. I will say I do have a direct connection to AAMDS and to bone marrow failure diseases, as my wife is a survivor of aplastic anemia, PNH, MDS, and a bone marrow transplant. So I have been a caregiver, and I do understand some of what individuals are going through. So just a disclaimer, which is unfortunately necessary, but what we're going to cover today is not legal advice. So any legal advice would really require the knowledge of your specific facts and circumstances, which are important to really analyzing your issues and making a real determination and formulating advice. So you would really need to consult a lawyer if you want specific legal advice. So the laws we're discussing and their rules and the case law interpreting those rules have a lot of nuances and little exceptions, and we just can't cover them all here. So just trying to give you some important context and background information about these laws, and just to, provide you some general guidance. But again, please contact the lawyer if you're confused or if you have really specific questions, or maybe most importantly, if you're actually having a dispute with your employer or Social Security or some other government agency about your situation. So just a slide is what we're going to cover today. We're going to talk about the Family Medical Leave Act, FMLA, and we're going to talk about the Americans with Disabilities Act. And that'll be the emphasis of our presentation today. I think those are likely the most critical laws for individuals working, that have PNH, bone marrow failure diseases. These are federal laws, and they apply nationwide. And just to note that with respect to these two laws, they aren't effective nationwide, but there are some state laws that also impact the same topics like leave and reasonable accommodations. Generally speaking, state laws can't provide you with less than the federal law, right? So they would really just be enhancing the federal law. But I'm going to talk about the FMLA and ADA, sort of what they cover specifically, and I'll mention a little bit about some state law state laws that interact with the same topics, but I can't cover, like I said before, I can't cover everything. So we'll also talk about some other topics that may be irrelevant for people who can't work anymore. So FMLA and ADA are relevant when you're trying to work. Disability insurance and Social Security disability are more relevant when you're disabled and can't work. So we'll talk a little bit about those things, and then a few other topics like privacy, like I said, state and local laws, and some informational resources I'll mention and discuss those that I think might be helpful to you. And then some questions. I'm going to try and, like Lee said, I'm going to try and answer some of the questions that I've already received, and then I'll probably recap them at the end. But please feel free to raise new questions as we go. Excuse me. All right, so starting with FMLA, just a little context. It was passed in 1993. It is a federal statute. It really was a big deal at the time. I had just entered the workforce then, but prior legislation covering family medical leave had been vetoed, I think more than once. And so this passing, I think under President Clinton, it was a big change. A lot of employers had really complained and really were concerned about the cost that this would impose on businesses, but it was passed, and I think made some real substantive changes in employee protections. It does have limitations, and it only offers a certain level of protection, but and we'll talk about that, but it can be an important tool for people, I think especially those with PNH. All right. Apologies. So we'll talk about who's covered, when leave must be granted, what leave must be maybe taken, some of the protections aside from leave that are covered by FMLA, the notice and communication process, and some questions. So who is covered? So first we look at employers. Which employers are covered under FMLA? Because it's not all employers. And this is sort of a threshold question. So if your employer is not covered by the FMLA scope and statute, you as an employee are not protected either. So I was doing some digging as to how many people are actually covered by FMLA, and it's hard to find any specific numbers, but I think most people were sort of, most people that have looked at this think it's around half to 3/4 of all workers are fall under FMLA protection. So specifically, the employer, there's sort of three different categories, and the first bullet point here is really will be the test most people will need to look to. So for private employers, if you don't work for a government or a local government or state government or the federal government, it's a private employer who employs 50 or more employees in 20 or more work weeks in the current calendar year or previous calendar year. So that's a lot of, it's a very legal, technical definition, but the first question is, are there 50 employees at this company? And that'll be measured by that 20 or more work weeks standard. And that's like I said, that's going to be what applies to most people. Second bullet point, public agencies, all employees are covered. So federal, state, and local governments, and educational agencies like school systems, all employees are covered. I will say there's some nuances to this. Like I said at the beginning, there's some special rules for teachers and airline crews, and I think there's some special rules for armed services members. So it's worth some digging to see if you fall into a special category, but the vast majority of people will fall under this first test for private employers. So now we look, if your employer is covered, now we look to see if you, the employee, are covered. So first threshold issue is, are you an employee? Meaning, are you an actual employee, or are you maybe an independent contractor? This FMLA does not cover independent contractors. It's intended to cover employees. Now, there is a gray area here. Many employers treat independent contractors that probably should really be treated as employees. They treat them as independent contractors. And this is an area that the Department of Labor, which enforces FMLA, they scrutinize this, and there have been cases where DOL has, cited companies for doing that very thing, treating people like independent contractors when they should have been employees. It's sort of impossible to discuss all the nuances to that here. The basic position is, though, if you're a independent contractor, a true independent contractor, you're not covered by FMLA. Also, you, the employee, have to have worked at the employer for 12 months. So for the past 12 months, and worked at least 1,250 hours during that 12-month period. So, it's a little more than half time, but you have to have worked that minimum amount in the prior 12 months with that employer to then leverage the protections. Also, there's a second important test. Are you employed at a work site where 50 or more employees are employed by the employer within 75 miles of that work site? So that's intended to cover situations where the employer is over 50 people, but it has multiple sites. So maybe it has 2 sites where there's 30 people each, and they're far apart, more than 75 miles. You may not be covered in that situation. Presumably that's to protect employers from, with smaller sites than the 50 employees from, I guess, the burden of losing people and offering leave. You can debate the wisdom of it, but that test is there. So it's something that you need to look at. So a point about remote workers, since this is sort of a big issue in the past several years. DOL, Department of Labor, issued some guidance earlier this year, and they basically said, employers have to treat remote workers the same. They get the same protections, which makes sense, but I think they were just reiterating that. But what they clarified is, if you're remote, your work site, for purposes of the test we just talked about, your work site will be where you report to. So maybe you work in, maybe your home is in Southern Virginia, but you remote work in your main office that you report to people at is in Washington, D.C. Washington, D.C. will be the site for this 50 or more employee test. So that sort of resolves, I think there may have been some situations where employers were saying everyone's work site was their home, right? And so naturally, many people might not be within that 75-mile distance. And so employers, I think maybe some employers were trying to get out of FMLA coverage by making that distinction. But Department of Labor has clarified that. All right, so now your employer's covered and you, the employee, are covered. When can you leverage FMLA? When can you ask for and get leave? So it's for your own serious health condition that makes you unable to perform the essential functions of your job. So the important term here is serious health condition. And there's multiple tests for that. A hospital stay is a serious, and the treatment that might come from that, that's a serious condition. Something that lasts for more than 3 days in a row and treatment after that is serious. If you're incapacitated and treated for that, a permanent or long-term condition for which treatment may not be effective, like if you had a severe stroke or something else that can't be fixed, but you're still functioning. That is covered. Absences for surgery and multiple treatments for a condition where if you weren't treated, you'd likely be incapacitated. There's a number of tests. I think the long and the short of it is, I think in the vast majority of cases, PNH patients would meet the serious health condition test. It's possible you would, have such a low clone, or you would have such minimal symptoms that it might not be covered. But in that case, you probably don't need leave. So in any event, I think most people would be covered. I think most doctors would agree. Also covered is sort of for your family members. So if you're a caregiver of someone who has a serious health condition, you get the same rights. Now, family member is restricted. It's child, spouse, parent. So sort of that immediate, child, spouse, parent structure. Child is, does include stepchildren, foster children, adopted children, adult children who are disabled. But there are limitations under the FMLA for this. It doesn't include like in-laws. It doesn't include grandparents. Extended family, cousins, etc., are not protected by FMLA. Like, we'll talk about some state laws that actually impact this, but for FMLA purposes, child, spouse, parent. And it also covers pregnancy and birth, adoption, and foster care. So for PNH, I think if you actually have hospitalization, if you have to have treatment, if scheduled treatment, if you have to have intermittent doctor's visits, I think these are the types of things that you'd be looking at for FMLA leave. All right, so when can you take leave? So you're entitled to 12 weeks of unpaid leave in a 12-month period. So not surprisingly, there's some nuances to that. So again, that's unpaid leave. It is not paid. You can take your paid leave as part of that. So let's say you have 2 weeks of vacation and 2 weeks of sick, or sometimes personal, called personal leave. Let's say you have 4 weeks of paid leave saved up. You can take that as part of your FMLA. So, you're paid for those 4 weeks, and then you have 8 more weeks of unpaid leave. And your employer can actually make you do it that way. So and oftentimes they will, because you're not entitled to sort of take your 12 weeks of unpaid leave and then your 4 weeks of paid leave, unless your employer agrees to it. So if they agree that you can do that, that's fine, but you can't make them do that, so you're not entitled to do that. You can take intermittent leave. So you can take, you don't have to take all 12 weeks at once. You can take 4 weeks and then, sometime later. It's just limited to the 12 work weeks in a 12-month period. So often, we're often asked, can I take FMLA more than once? So theoretically, yes. But you can never take more than 26 weeks per year, and you still have to have met the 1,250 hours in the preceding 12 months. So if you've already leveraged FMLA for 12 weeks and you wanted to do it again, you still have to have met the 1,250 hour rule. So that's a consideration. But there's an important wrinkle here. Your employer decides when that year period is measured. And they can do it a number of different ways. They could measure it by calendar year. So you can imagine a situation where you are out on leave for October and November, and then come back and then need to leverage FMLA again for February and March. If your employer measured it by calendar year, that might be okay. However, they are allowed to measure it sort of based on when you've started your first FMLA period. So they are allowed to say, well, you started in October, so that's the start of your year, in which case you wouldn't be allowed to use FMLA again until the following October. Like I said, employers can set that up. They should have a policy on this, so they shouldn't be changing it per person, right? It should be a standard policy, and if they aren't following a standard policy, then that's something you may want to follow up on and look at. But they are allowed to set that. All right. So we've covered the leave and what you can take, right? But there are some other protections. Your employer is required to continue your benefits and, probably most importantly, your health insurance when you're on leave. However, something to watch out for, if it's unpaid leave and you make employee contributions to your healthcare, you may need to do that. So it's worth coordinating if you're going to be out for a long period of unpaid leave. It's worth coordinating with your HR payroll to see if you need to keep contributing your portion of your insurance. And I guess I've seen that issue arise for other clients. As long as you are able to return to work before you exhaust your leave, you should be returned to the same job or one nearly identical. And what we mean by same job is either the exact job you had or one with the same responsibility, pay, and benefits. There are some exceptions to this. If you're a very highly compensated individual, if you're in like the top 10% of pay at your employer, they may not be required. Your employer may not be required to honor this if it's a hardship for them. So again, another case where there's some exceptions to almost all of these rules. And then any time off from the FMLA, any time off under approved FMLA may not be held against you in other things like hiring and promotions and things like that. I think time into your position, if your position requires like a year before going to the next level, I don't think they can hold that against you. So it's it's not supposed to taking this leave is not supposed to hinder you in those other ways either. I will say, this is not a complete protection. So if you can be fired if everyone else, if you're fired not because you're on FMLA. So if your division is laid off, your employer can treat you equally as to the other people that are similarly situated, right? So it's not an absolute protection, but you are not supposed to be discriminated against because you took FMLA. The enforcement of FMLA falls under Department of Labor. So if you're having sort of an unresolvable issue, the Department of Labor Wage and Hour Division enforces FMLA. You can go to their website and find your appropriate office, and you can file a complaint. That's obviously something you want to consider before doing, but at the same time, if you're pushed to a point where you're being discriminated against or consistently denied leave and you don't have any other option, that may be something you need to do. So a few words about the process. So wherever you can, you're supposed to give 30 days notice of FMLA leave. So if in 2 months, I'm going to have this hospitalization, major treatment, you should give your employer at least 30 days notice. That, of course, is not always possible. So you just have, when not possible, you have to give them as soon as practical notice. So, that might just be a day's notice, but you should do it as soon as you can. You can give them oral notice, and you should try and, to the extent disclose, okay, I think this is going to be a 2-day, a 2-day issue, or just 1 day, or I'm going to be out a week, or my doctor advises I could be out as long as a week, that kind of thing. You don't have to disclose your specific diagnosis, but you do need to provide enough information to establish that you're FMLA protected. So, it could be that you don't say you have PNH, but you have sort of a hematological issue, something that, is communicating to the employer that you have sort of a chronic or permanent or, condition that requires medical care, medical oversight. Your employer can ask for, a doctor's note. They can say, I would like to see that. And, I think most PNH patients you have doctors you're going to, and you can ask them for that note. And I doubt there'd be any problem with that. And that should be the end of it once it's provided to the employer. Your employer, once you ask, your employer should be notifying you within 5 days of, they've granted it, or if they haven't granted it. Again, this is sort of a documentation thing, and sometimes the whole thing happens faster than this, but that's sort of the general rule. So if you're telling them 30 days in advance, you're supposed to get back like within 5 days. Okay, this sounds good, or we're asking you for a doctor's note, or we're denying it for these reasons. My overall advice is to be proactive. I know there's a lot going on, and even from my personal experience and with prior clients, I know it's not always easy to manage some of these details. But the FMLA leave can be very important to you, and so if you have a caregiver or someone else that can help, just try and stay on top of this and be proactive. I think, in my experience, employers, the biggest issue they have is surprises. That's what bothers them the most. And so when you can give them some notice and work with them, and that they, as a general matter, appreciate that. And I think that's to your benefit. All right. I mentioned state and local laws. I'm just going to cover a few points. I didn't review all the state laws, but I do know some have enacted their own sort of FMLA or other laws that enhance leave rates. Like I said, they can't reduce the FMLA benefits, they can enhance it. So these could be important to you, and you may want to look into that if if this is an issue for you. As a general matter, and this isn't a comment, I think it's just a fact. It's more of your traditional blue states that offer more protections. Not a hard and fast rule, but it just generally tends to shake out that way. So as an example, a few states have lowered the 50 employee test. So recall we talked about the employer has to have 50 employees and then 50 within the 75-mile radius if at more than one site. Some states have lowered that, like Maryland, where I live, that they've lowered it to 15. Other states, I think Oregon is 25. Vermont, I believe, is 10. So it, that's a much different standard. 10 is much different than 50. It's going to capture a lot of other employers. Some states also have expanded coverage. For example, Hawaii does cover grandparents, and some states cover in-laws. So you could have an expansion of scope depending on what state you live in. A few other things that I think are interesting and relevant. Some states have FMLA for organ and bone marrow donation. Maryland has both, I believe, and up to 30 days of FMLA if you've donated bone marrow. So that's a nice. There's a few states have done that. I think that's a nice, helpful way of sort of supporting that process. And then last, some states have actually enacted paid medical leave. So, the FMLA is unpaid, but some states have laws that say you actually have to pay employees while they're on medical leave. And that, I think, includes California, New York, Massachusetts, Connecticut. I think Maryland has passed that law, although it's not, I don't think it's in effect yet. But so again, I think most employers would have incorporated that into their process, but not always. So something to consider. Okay, so I don't see any chat questions, but there are a few things that are typically asked. So Chris, who isn't covered? Well, if you're, like I said, if your employer is not covered, you're not covered. If they don't meet the 50 employee test, except for those states that have lowered the threshold, you're not covered. If you haven't worked there a year or haven't worked there the 1,250 hours, you're not covered. Short-term illnesses like a cold and routine medical checkups, that's not covered. And last, because I have been asked this question, pets are not covered. So unfortunately, I know we all think of them as family, but they're not covered by FMLA. And then I often ask, what do I do when my employer is being difficult? So, this is very dependent on your own circumstances, but try to make sure you've done what you needed to do. The notice requirement, communicating with your employer, trying to keep them informed of what's happening with you. If they're just not doing what you think they need to be doing, if it's your manager or supervisor, you may need to go to HR. You may need to escalate up, above your manager. And then in more extreme circumstances, you may need a lawyer or you may need to file a complaint. And like I said, that's with the Department of Labor. So not fun. Obviously, it's difficult. Those are difficult circumstances, but those are the kinds of things to consider.
Chris, we have a question.
Sure.
One says, if the employer eliminates your position as part of downsizing, you have no resource, correct?
That's possible, yes. If they're just downsizing and not eliminating your position because you're on FMLA, it is possible that's allowable.
There was a follow-up. It says, I meant while you're on FMLA, your employer eliminates your position.
Yeah. So like I said, it is possible your position can be eliminated if it's not for discriminatory reasons. So you're like, we chatted briefly that you're not protected in all circumstances. Your employer is allowed to do the things it might normally do. So if it downsizes your division and you're part of that, you're not necessarily protected by the FMLA.
Chris, if somebody is deemed permanently disabled, does that mean that they're never able to return back to work should circumstances change?
So if you're permanently, well, I don't know exactly what is meant by permanently disabled. There's various contexts that could come up in. So there's workers' comp, there's disability under ADA, there's Social Security disability. But if you're disabled, then you're not working, right? I mean, it's possible that there are circumstances where people who cannot work, their inability to work is temporary, right? So then you come out of that and you can work full time again. My wife is an example. She did not work for quite some time when she had a bone marrow transplant, but she now works full time again. So I'm not quite sure what the context of permanent disability is, but you cannot get disability benefits and then return to work full time. Like for example, if you're receiving disability benefits from the Social Security Administration, so they have found you to be disabled, returning to work will impact those benefits and most likely in the not too distant future eliminate them. They have a return to work program, like a trial program where you can try and return to work and they won't hold that against you if that doesn't work out. But you can't collect benefits and then go back to work on top of it. Maybe if that person if I didn't answer that, maybe that person could add some questions and we can come back to it towards the end.
Thanks, Chris. Do you need an attorney when you are discussing with your employer accommodations?
So let's hold on that. I'm going to talk about ADA next. So that's our next topic is the Americans with Disabilities Act, and that's where accommodations come up. Is that it, Lee?
Yes.
Okay. All right. Okay, so our next big topic, the Americans with Disabilities Act. That's our second federal statute, and again, another one applying to when you are trying to work, and as the last questioner posed, covers accommodations. FMLA is about leave, ADA is about accommodations. So we're going to talk about the law, who's considered disabled, qualifying for protection, what the protections are, and what are your sort of obligations or things you should be doing. So the ADA is a little less specific and a little more qualitative than FMLA. It's a little wordier. So I'm going to do my best to summarize it for you. It's not as crystal clear as things like as some of the tests under the FMLA, but the ADA covers a lot of things. It covers telecom, education, building access, but we're going to focus on employment. So the law was passed in 1990 and it was under President Bush, and it also was a very big deal at the time for people with disabilities. And it was resisted for, I think, some of the same reasons we talked about under the FMLA. And it has taken, it's been in effect for over 30 years, and it has taken a lot of work by the Justice Department, who's mostly enforces the the ADA obligations. And I raise this because I know a number of lawyers in the Civil Rights Division of the Justice Department, and they spend a lot of time and effort making sure businesses comply. And I think it's really resulted in a number of important changes for people with disabilities. Just some further context, there was an amendment in 2008 to the ADA, which is called the ADA Amendments Act, or the ADAAA, which is a terrible acronym, but and that act actually expanded some coverages. There had been some Supreme Court cases that had put some limitations on the ADA that Congress at the time, Congress didn't agree with, so they overruled those cases. As probably the biggest example was the Supreme Court had said if you are able to mitigate your disability, as an example, if you're an amputee with a prosthetic, you may not be considered disabled. And Congress, overrode that, because the point is you are disabled, right? Just because you've compensated for it doesn't mean you're not disabled, and so you still need the protections of the act. So that's one of the things it did. It also, I'll talk about some of the other things as we go, but it also has a threshold requirement of 15 employees. So the employer has to have 15 employees, which is a pretty low number, but still cuts out some employers. So that's who it covers in terms of employers. And in terms of working, like I said, ADA covers a lot of things in life, but in terms of working, it prohibits private employers, state and local governments, employment agencies, labor unions, et cetera, from discriminating against qualified individuals with disabilities in a whole host of aspects of employment. All right, so who is considered disabled? There's sort of three tests. The main one is this first one. A person who has a physical or mental impairment that substantially limits one or more major life activities. This is very kind of vague language, but substantially limits is key to this. So it doesn't have to prevent the activity. It doesn't have to prevent you from working. It can just impede working and still qualify. It's not meant to cover every impairment. Hard to come up with examples, but this is something often considered, with eyesight that's correctable by glasses. That's something that's kind of accepted, that's something we all do, many of us do, including myself. But in terms of other impairments, it's this substantially limits test that we use. And then major life activities, this is things like walking, standing, bending, breathing, speaking, reading, concentrating, etc. And of course, PNH can affect some of that. In the 2008 amendments that I raised, Congress also included major bodily functions as a major life activity. This is sort of an important change, because it can touch upon some of the more invisible diseases. So your PNH, your hematological activity, I think would be a major life activity now, and things like cell growth inhibition and immune system issues, those would fall under, I believe, the amendments where they might not have previously. So the second test here is if you have a record of an impairment. So you can be considered disabled if you have a record of impairment. The second test is meant to capture, okay, I was six months ago or a year ago, and I was found to be disabled, but I'm okay now, so I'm in remission, or I'm fine for this time period. While you're still, the ADA would still cover you, okay, because you have a record of that impairment. So it's meant to capture those situations for people who may not be have the same consistent level of disability, right? Which I think is relevant to bone marrow failure diseases. So who is disabled or who qualifies for protection? So a qualified employee or applicant with a disability is an individual who, with or without a reasonable accommodation, can perform the job. To say it a little differently, if you have a disability and can do the job with a disability, you're protected. If you have a disability and can do the job with a reasonable accommodation, you're protected. So it's trying to sort of make sure both of those categories of people are protected. But you must, in either case, you have to be able to meet the essential functions of the job. Your, education, employment experience, skills, the standard things your employer requires and requires of everybody, can apply to you. And if your reasonable accommodation can't get you past that, then, you're not going to be protected. So the type of protections we're talking about include things like modifying a job or an employment practice, making a facility accessible. We're all familiar with that example. Wheelchair accessibility is something we all are familiar with. Something like modifying a work schedule, that's also something that may be considered a reasonable accommodation. I can't give you any bright lines here because people may have different impacted functionality on PNH, right? If you have PNH, you might have a more minimal impact or none, and you might have a more severe impact. But some of the things for PNH patients to think about, you might need periodic breaks or a rest area or somewhere to take medication, maybe a modified work schedule that would allow you some rest periods or you're better earlier in the day than later in the day. If there's a marginal task that you do that is difficult, but it could be done by someone else, might be a fair accommodation. Possibly reassignment. So, to a different office or an area of the building or a different group, if you can do the work, that might be an accommodation. I know one that's on many people's minds is working from home, right? Because I either have immune issues or I don't want to be exposed in commuting, to other people. That's something that might often be asked for. And of course, we've seen over the past couple of years, it's implementable by many companies. So the EEOC enforces the ADA in terms of the workplace, and it provides guidance. So the EEOC has weighed in and said it's not an automatic accommodation that you can work from home. That's their guidance on the topic. But I think, if your employer has done that in the past, or if there are other people working from home, I feel like it's certainly, you're in a better position now than in a few years ago, right, before the pandemic, to argue this is a reasonable accommodation, because it's been so widely shown that it's doable, as long as your job lends itself to something like that. And like I said, especially if others have done it or are doing it, it might be very difficult for an employer to say you can't. Employers do not have to give you an accommodation that would constitute an undue hardship for them. So this is another sort of gray test, vague test, but that's generally considered to be significant difficulty or expense. They don't have to do that. That will depend on like the size of the employer. You know, a smaller company may not be able to absorb putting in, you know, redoing the bathrooms and putting in a wheelchair ramp. A larger company might be able to do that. You know, a larger company may be able to absorb redistributing some of your tasks or letting you work from home. So, like I said, it's not a slam dunk. The employer can make a case for undue hardship, and it's just going to come down to the specific facts of, you know, your job, the accommodation you need, etc. So, you know, the protections, like we talked about, they're protect disabled employees, qualified disabled employees are protected in terms of hiring and firing, compensation, reclassification, demotion, job advertisements, you know, recruiting, all these, almost every single aspect of employment. You cannot be discriminated against because you're a qualified individual with a disability. And you're also protected against retaliation. So if you received an accommodation, you shouldn't be retaliated because you got that. And if you had to seek out EEOC assistance in asserting your rights, you can't be retaliated against because you did that. So, and like so, that's a segue into, as I said, the EEOC does enforce the ADA. And so if you aren't getting what you need through your employer, and you know you feel like there's no other choice, you can go to the EEOC and file a complaint. It's basically a discrimination complaint, like other forms of discrimination. I will say there are time limits on these things, so you should not sit, as we say in the law, sit on your rights. You know, you need to decide. I believe it's 180 days from the violation for private employers. It's much shorter for government employees. So, you know, from the date of the violation, there's a clock ticking, and if you're past that date, you can't complain anymore. So you have to take action. So there aren't really any magic words for actually requesting the accommodation. You basically go to your employer and you talk to them about what you think you need and why you're a qualified individual with a disability. Your employer may have some questions. They're not allowed to dig into your entire medical history, but they are allowed to ask enough questions to sort of justify. And of course, this is where doctor's notes and other things come in and are helpful. And I know this is an issue with many clients in the past. Sometimes, cancers and bone marrow failures, people don't look sick, right? It's not, it's sort of like, well, why can't you do it? But, of course, you may have fatigue and focus issues and all kind of, pain or any of the host of other symptoms that come from the disease or the treatment, right, of the disease. So in any event, you may have to have some dialogue with your employer, but, like I said, they can't dive into your entire medical history. It is good to have a plan. So, I advise clients, don't just go in and say, I have this, what are you going to do? Think through as best you can, like what would help you, and what kind of accommodation would truly help you. A schedule fix. Leave can be an accommodation, and is an an overlap with FMLA. You might not be covered under FMLA yet because you haven't worked there a year, but intermittent leave might be a form of ADA accommodation, meaning, I need Friday afternoons off, but I'll make up the time somewhere else. It is possible that it would work that way. But again, try and communicate with your employer on the topic and have a plan. So questions here, Lee?
Yes, one is the question earlier was when you are going in to speak with your employer, requesting an accommodation, do you need an attorney?
Right, thank you. No, these things are intended to, work the FMLA process and the ADA process. They're intended to work without lawyers. You, like I said, you go to your employer and you advise them of what you need. They may have some forms. They may ask some questions. They may ask for a doctor's note. But you should not need an attorney for the process. Attorneys come in when you're being consistently denied or when some action is taken against you because you have a disability or because you asked for FMLA. Of course, you can always consult an attorney. That's your prerogative. But the system is set up for, at least for the initial part, if everything's going okay, you shouldn't need an attorney. Also, thanks. I believe someone asked about caregivers and the ADA. So caregivers cannot get accommodations based on the disability of their loved one. So that is not covered. And they are protected against discrimination because of the disability of their loved one. So if someone knows, the husband's at work and the wife has PNH and people find out at the husband's work, she has PNH and there's some misperception that that's going to raise their medical insurance and they fire the husband. That is covered under the ADA.
Okay.
That's discrimination. But in that scenario, the husband cannot get an accommodation based on the wife's illness.
Thanks, Chris. This question is regarding to applying for new jobs. At what point do you need, or do you even need to disclose your illness in the event that you may need accommodations in the future?
So this is a common and very good question. So you're not required to disclose anything in the interview process. And their employers are not allowed to ask you medical stuff in the interview process. However, at some point, if you're going to need the accommodation, right, you can wait till you get an offer. You can discuss it at the offer stage, but you don't have to disclose it then. You'd only need to disclose it when you're looking for the accommodation. And this is a balancing act. Of course, we can all understand especially if it's a more serious accommodation, something that might have effects on the employer and the employer's smaller, you might want to raise it at the offer stage. I typically would not raise it at the just general interview stage.
And Chris, when talking to your employer about the need for accommodations, is it also advised to have like follow-ups in writing? Should you be submitting your request for accommodations in writing, or is it all just done verbally on behalf of from the employee to the employer?
So I certainly think you can start the process verbally. if there's an agreement, I would document it, right? At least for yourself, but I think it's worth, you can message it tactfully, but it's worth sort of, documenting with your supervisor or whoever else has approved this, that we agreed that I can modify my work schedule in this way, and I will update you in 6 months or 3 months of whether this is working, or I no longer need the accommodation, right? So initially, verbally is fine. Your employer may have a form they want, especially bigger employers tend to have processes for these kinds of things, which would often just naturally get them documented. But if there's an actual agreement as to what's going to be done for you, I do think it's worth putting that down in writing at that point, so that everyone sort of knows, right, what's going on. Because then your supervisor might move, or you get a different supervisor, and now as well we have this verbal agreement. It's worth documenting at that point.
Thanks, Chris. If an employee is on FMLA and then the 12 weeks is coming and they need to continue a few more weeks, can FMLA be extended? Is it best for the employee to ask for short-term disability? How can someone extend being out longer than the 12 weeks if necessary?
Right. So your FMLA only covers 12 weeks. That is all your employer's obligated to give you. They can extend it. And I've seen all kinds of employers. I've seen employers not meet their minimum obligations, and I've seen many employers bend over backwards for sick employees, and give them more than they're obligated to give them. This has happened with friends and even my wife and others. I've been surprised in some cases at the willingness of employers to be helpful. But the FMLA is 12 weeks and 12 weeks only. You can ask for an extension, but you're not guaranteed. So, and honestly, your employer does not have to hold your position open after that. So,
Okay.
that's a real issue. There may be, if you are really disabled and aren't able to work, there may be other options like short-term disability. And you would definitely want to look at something like that, because that might offer, if your company has a short-term disability policy, make sure you're aligning that with your FMLA, and make sure, if you think that might be the case, you might want to get that going before definitely want to get that going before FMLA runs out, because you might get more protection that way if you're qualified for the employer, for your company's short-term disability.
Thanks, Chris. And we had a question come in. It says, regarding ADA, when you were discussing the eligibility of disability and mentioned that you can have a record of disability in the past and be in remission, how far back can this record be from in order to be legally meeting the established disability eligibility? You mentioned a year, but could it be more than a year, like 3 to 5 years?
So yeah, I don't believe there's a hard and fast rule on it. I think it could be more than a year. If someone has PNH, and and I apologize, I'm not as familiar with PNH as I am with some of the other bone marrow failure diseases, but if you're in remission and it comes back 3 years later, I think that's very possible will qualify for that, but it would also be its own new disability anyway, most likely. So I wouldn't get hung up on the record of it. It's intended to sort of cover that remission. And I do think it could, I don't think there's a specific time limitation. Of course, the longer it is, that might be relevant. But if you have a new flare up, or if something has come back, even in a different way, it probably will just qualify under the first test anyway.
Thank you. Chris, when somebody is interviewing for a position and they know, for instance, if you're diagnosed with a bone marrow failure disease, and you may need accommodations in the future, is it appropriate, or how would someone who is interviewing find out about, like, what are their policies, or anything that they've done in the past to accommodate any needs?
That's a good question. I think any sort of targeted request would look odd, right? If you're not disclosing what's going on, if you sort of started asking about prior accommodations and policies, I think that would raise some flags at the potential employer. In terms of, I don't know that you'd have any way of really finding out exactly what kind of accommodations they offer. I think that's a case of, you have to think that they would comply with the law, right? And provide reasonable accommodations going forward. I don't know of any way to sort of get at exactly how they'd approach it.
Chris, would it be appropriate for somebody when they're asking their questions in an interview to ask what type of benefits they have and see if they have a short-term disability
Of course,
policy? Would that be like an indication that there would be an option for a patient should they need it?
So yeah, disability insurance is great, and long-term and short-term, and I'm going to talk about that in a minute, are great benefits that not every employer offers. I think you can ask about the scope of those kinds of benefits without raising any major flags with anyone. But I don't know that having a short-term disability program in and of itself says, that employer is going to be more reasonable than others.
Thank you, Chris.
Okay. So just, I did want to talk about, and this is at a little more high level, some of the disability, some important disability insurance and programs if you are actually disabled, because this has come up for clients many times in the past. So in this case, we are talking about you're disabled and you can't work. So what are some of the options? There are long-term and short-term disability programs that some employers provide. They're not required to provide those. And those are very different than, statutory obligations like the FMLA and the ADA. They're basically contracts. It's basically a benefit you and or your employer are paying for. And the disability insurer pays the disability benefit if you meet the requirements for being disabled. Because it's a contract, they vary from employer to employer, although a lot are generally similar. They do vary. They might vary in how much they pay. They might vary in the specific terms. If you've never read through a long-term or short-term disability agreement, it's painful, it's tricky, it's tough to read. It's just the way it is. The pay is typically, I've seen like 40 to 80% for long-term disability, and maybe towards the higher end of that for short-term. People often ask whether that income is taxable, which depends on who paid for the premium. If your employer paid for the benefit, it's likely taxable, the income from it. If you paid for it entirely, I believe it's likely not taxable. And then long-term, there are employers who offer long-term but not short-term disability. So if you have long-term disability coverage but not short-term, there may be what we call like an elimination period, or a period where you have to be disabled for 3 to 6 months before the long-term disability benefits kick in. So the short term usually covers that, that initial period, and then the long term kicks in after that. One really important item is disability insurance contracts can have pre-existing condition clauses. So I know that's something a lot of people pay attention to. Your medical insurance coverage, you can't be, you cannot have pre-existing condition exclusions if you have continuous medical coverage. So that was fixed a while ago. But disability contracts can have that. So if you have a finding of a condition and then you quit and go to a new employer that has disability insurance, it is possible that your previously identified condition would not be covered. So, or that it's not covered for a certain period of time. So I do tell people to think about that when they're job switching. If, it's likely not the determinative of what you're going to do, but it is something to think about. Let's see. Also with insurance, disability insurance, it is a benefit, and sometimes your employer's HR department handles it, or they've hired someone else to handle it. I mean, if they're paying for it, I think if it's insurance they're paying for, your employer, usually I think they want to see you get the benefit of it. But, so they might help you in engaging with the insurance company if you're having any trouble with the insurance company and their definition of disability. Or this third-party benefits manager, they might help you as well. So I know one example I had when I really first started helping people was a woman who had leukemia. She was denied short-term disability because of an employment change. And it turned out, after we did some digging, the benefits manager figured out that the company paid for some extra protection to eliminate the pre-existing condition clause. So she was initially denied, but we dug around a little bit and it turned out she shouldn't have been. So she actually got the benefit. So sometimes it's just a matter of hanging in there and making sure you've checked everything you can to ensure you've gotten what you're supposed to get. If you are getting long-term, short-term disability, you have to cooperate with the insurer. You have to fill out their forms and do what they say. And as an example, in long-term disability, they will make you apply for Social Security benefits. And they will then, when you get them, they will then deduct those benefits from the benefits they give you. So I don't know if that's the case for all of them, but I think most of them do that. So it's just a process that you really have to pay attention to, because you can lose certain rights if you're not complying. All right, so that's just some notes about disability insurance. We could all talk about this for a whole day, but just some things I've found along the way that's important. The Social Security disability process, this is the federal government's program, right? Administered by the Social Security Administration. There's two programs, one's SSI and one's SSDI. SSDI is the Social Security disability insurance that most of you are familiar with by paying into the program, and you get those statements that say these will be your benefits when you retire. That if you're disabled, that's how your benefits are calculated under the SSDI. In 2022, I looked it up. It looked like the average monthly benefit was about $1,680 for SSDI. SSI is more of what might be called the welfare program for people who haven't worked, for children and others. you haven't paid into that to the SSDI fund, that's a more of a catch-all category, and that's a much lower benefit. So that average benefit for 2022, the monthly benefit was only $622, so much less. The application process for Social Security, it's about a 3 to 5 month process. So for the review of your application, but something I always tell everyone is benefits will start based on the date of your application, not the date you were sick. So think about that. Don't put off the application if you think you're going to end up doing it. A note about the 3 to 5 month review process. So if it takes 5 months to review it, right, and then they find you're disabled, Social Security pays you back to the application date. So it doesn't start when they approve it. They'll pay you back to your application date. And there is something called the Compassionate Allowance Program, which can expedite reviews. And I believe at least certain types of aplastic anemia and MDS are on the Compassionate Allowance Program. I don't believe PNH is on the list. So the definition of disability under Social Security is different. So I'll talk about that more in a minute. And Social Security is only going to pay for disabilities that's expected to last for at least a year, or for people who are not expected to survive long term. So it's a much more restrictive standard, and they don't pay for partial disability, and they don't pay for short-term disability. So it's basically a long-term disability finding, and that's when you may be eligible for benefits. So how do they determine your disability? They'll look at, can you work? Can you earn? If you can, you're probably not disabled. Is your condition severe? The definition of severe is not crystal clear. The way Social Security goes about it is they look at whether your disability falls under the list of disabling conditions. So they call that the Blue Book. And they basically have a big list in there of things that are automatically, disabling. Certain hematological disorders are, and you are considered to be disabled for a certain period of time after certain types of bone marrow transplants. And if you meet the, and then I think certain types of aplastic anemia and MDS are also listed in the Blue Book. So I don't think PNH is. So that doesn't mean you can't get a finding of disability. It just means it's not sort of automatically listed. So if you are otherwise impaired still because of your condition to the point where you can't work, you can show that to Social Security through other means, right? And so you establish for them that you cannot, sit for long periods. It's very dependent on the impact you're experiencing, but they will look at the functional limitations, like can you pick things up, can you sit, can you stand for long periods of time, how much weight can you pick up, can you take care of yourself, can you drive. So all these things will go into their evaluation. You will need to provide extensive medical documentation as part of your application, and you should try to establish as best you can how your illness is impacting your work, your ability to work, and all aspects of your life. So you can put in just basically narrative statements along with your Social Security application. I've had cases where I had other caregivers provide those statements. But, the critical part of it is the medical documentation. You will need to get all of your medical documentation to Social Security. They will evaluate it. They may assign their own doctor to evaluate it. They may assign someone to evaluate you and any functional limitations you might have. So that's what takes up that several month process. And it is a process. And I have to say, as much effort you can put into the front end of it to make it a complete application, it will serve you well along the way. Because as you can imagine, it's a huge agency with a lot of applications and, a certain amount of resources, and things might get kicked out, just because they haven't met some technicality. I mentioned the filing date and when payments start. Just a note about denials and appeals at the Social Security Administration. There's several levels of appeals. So when you first apply, the average success rate is about 38%. So these are based on Social Security's most recent numbers. And then the second level, so if you're denied at the first level, you can do what's called a request for reconsideration, which is basically they give it to someone else to evaluate. And this has a very low success rate. I think it's like 15%. You can then appeal again and ask for an administrative law judge hearing. I've done a few of those with clients. That has a much higher success rate, a 50% success rate. That could be because at that stage, a lot of people do get lawyers. It can be a complicated hearing, and it's not something I would suggest doing without a lawyer. You are supposed to be able to do the application yourself without a lawyer. I don't think you necessarily need one. If you find it too confusing or overwhelming, it may be that an experienced person or friend or loved one might be more help than a lawyer at that stage. But if you're at the administrative hearing level stage, you should definitely be considering a lawyer. If you're denied at that level, you can go for another appeal, and ultimately you can ask for a trial in a federal court, and that ends up being like less than 1% of all cases. So it is a multi-level process. I think overall the statistic is around 50% of the people who start the process ultimately are accepted for benefits. That's not to say that applies to PNH or bone marrow failure cases specifically, just sort of giving you a high level percentages. I don't have percentages on any particular disease. Okay, we've talked about some of the privacy issues in response to the questions. This, like I said, this is a tricky issue, right? You don't want to disclose personal medical information, but you have, if you need an accommodation or you need leave, you're going to have to disclose it to a certain level. And what you say and how you say it often depends on your relationship with the employer, how difficult they are or accommodating they are. Are you a great employee? Does everyone like you? Can matter. I'm not saying that should matter, but it can. So it's difficult for me to give you advice in a vacuum. Honesty and like I said, trying not to surprise people, I think, are good guideposts. I would not say too much too soon. And when you finally have to engage in the process, tell them what they need to know. But like I said, you don't have to disclose your entire medical history. What you do disclose is protected, so your employer should not be sharing it with others. And, really, even your supervisor shouldn't know things other than what they need to know to work with, to grant the accommodation, rights. They may need to know that you have an alternate schedule. They don't need to know all the medical reasons why. I'm going to cut off there because I'm running a little bit long, and I think I answered some of these. So I will say just a few other items, living with PNH, other considerations. I mentioned the state and local laws. There are potentially some agreements that impact how you do things. Like you may have an employee handbook, you may have an employment contract. Your employer may have policies and procedures about FMLA and ADA. Certainly look at those. They're not allowed to change what the law allows, right? But they are allowed to have some forms and policies and procedures. And you should take a look at those and follow those. Where unless for some reason you think they're diminishing your rights. And then last, some other resources. I put some web links in, but generally these are. The Department of Labor has FMLA guidance, like I talked about. They have a fact sheet. They have FAQs. There's also an employer's guide to the FMLA, which sometimes it's good to know what what the other side is being told. The Department of Justice, as I mentioned, addresses the ADA, as does the EEOC. I typed this wrong, but it's the EOC that enforces workplace ADA issues. So there's a number of different rights guides on their website. I think some other large, disease-based organizations also sometimes provide some guidance on things like FMLA and the ADA. And then last, sometimes if you really need a lawyer, sometimes there are free legal resources. It's often dependent on your ability to pay. And I can't point you to anything specifically, but I know, like for myself, I've done work for legal services in Northern Virginia and the DC Bar, and represented people in the Social Security disability process for free that the DC Bar referred to me. So that's some internet research. If you think it would be a bit of a hardship to pay, there may be some resources for you out there. Check bar websites and type in things like free legal services in my area, etc. There may be something there for you. So. Final questions. I think again, I'm a little long, so I think I touched on everything that was asked beforehand.
Yes. Thank you so much, Chris.
Any final questions?
Yeah, I think that was it. I think you got the last ones that showed up in the Q&A box.
Okay.
Yeah. Well, thank you so much, Chris, for sharing all of your time and your expertise. And we have a few slides that we'd like to show at the end here for just so everyone will know about some additional resources that we're able to provide as well. So we'll take just a couple of minutes to go over those resources for everyone. Nikki, go ahead and advance to the next slide. One is regarding the PNH registry, and the registry is open to PNH patients. Nikki, go ahead and switch to the next slide. It gives a little bit of detail about what is the registry. Our registry is different. The registry is very different. This is patient entered data versus physician entered data. Everything is anonymous for patients to be able to enter in their information about their diagnostic history, their symptoms, quality of life, and treatment. Being able to participate in research and helping doctors and patients better understand what PNH patients experience and go through. So if you're interested in more information about the registry, please do take a few minutes and take a look at our website. And then you can see about participating. This year, we were very happy to be able to launch the PNH toolkit. The toolkit has lots of great information. It's all up to date on all the treatment options, understanding the diagnosis, managing those side effects of treatments and side effects of the disease. And there's some great tools to be able to help you with organizing all of your appointments and your medical team. And then also included in the toolkit is the emergency healthcare cards for you to be able to utilize in case of an emergency. The toolkit, you can either download all of the pages on our website, or you can also let us know and we can send you out a hard copy of our toolkits. Next slide. For PNH patients who are in the process of being diagnosed, or you've already been diagnosed and you are looking to travel to get a second opinion, we're very pleased to be able to offer the PNH Patient Travel Assistance Fund. This is an opportunity to receive up to $800 to be able to travel to see a specialist. The application and further information is also listed on our website, or you can just shoot us an email and we're happy to help you with answering any questions about the travel fund. And the grant is open to patients once a year. So if you've already applied for a grant and last year, you certainly can be able to apply again. We hope that all of the resources that are shared today will be very helpful to everyone. Thanks again, Chris, for sharing your time and your expertise with all of us today. And if you'd like to watch this webinar again at a later time, it will be available on our website within just 2 to 3 business days. If you have any additional questions, please feel free to send it to us at any time in 3 ways. Send an email to help@aamds.org. You can give us a call at 800-747-2820, or you can submit your question to our Facebook page. On behalf of the Aplastic Anemia and MDS International Foundation, I'd like to thank you for joining us today and making us your resource of choice for information on bone marrow failure diseases. Our medical advisory board and team are always here to support you and your family, as we've done for the past 40 years. This concludes our program.